Good morning friends, Namaskar, Sat Sri Akal and Adab. This is my 201st video. Now this is going to cover a very important case which was fought by Mr. T.N.Whal of Kamptee, Bungalow number 29, civil suit number 1622 of 1998. So he had asked for a declaration plus mandatory injunction because his mutation was not being taken over by the department after his mother's death. So what was the pleading in his case is very important. Friends, this case, please understand this case like Mannalal Agarwal, like this. These are two cases which have been actually fought by bungalow owners. Entire evidence has come on record. So the pleading is that Mr. Whal is in physical possession of bungalow number 29. And since the inception, like since the making of the Kamptee Cantonment, he has been, or his predecessors have been in occupation. Further, Kamptee Cantonment possesses private bungalows. Since when? 1873. A Government of India order that private bungalows exist within Kamptee. So there is a will for this of Mrs. Vidyawati. Mrs. Vidyawati's sale deed is there of 1970 where she purchases the bungalow. So government actually, after a lot of correspondence, asked Mr. Whal to go to court. It's a very clear line written, and this was the cause of action where Mr. Whal approached the court for declaration and mandatory injunction. Now he speaks of, in his brief of plaint, the history of Kamptee, that it was actually a civil municipality and later it was converted into a cantonment. Now cantonment was a semi-defense establishment, what he pleads, and the rules applicable were only within the cantonment and not in the civil municipality areas of the Kamptee. So the applicability was pleaded. No government circular has been shown that when land was acquired for making of Kamptee Cantonment. So acquisition, he says, cannot be on a presumption that since I could not prove it, so it is presumed that this is government land. Whether they acquired it or not, there is a little difference. He is not presuming whether this is government land or his land. He says whether it was acquired or whether it was not acquired. So the title of any person, he says, flows through a specific document, and that document could be acquisition, will, sale and gift, anything like this. So on a presumption, now the entire presumption makes the government take us admission deed when we apply for mutation, he says. Now does the Cantonment Code 1899 or 1912 speak of a register of transfer to be maintained, a register for mutation to be maintained? Where are those? Then only the admission deed should follow. In his briefing para in the last of the plaint, he says that there was a treaty between the Raja of Kamptee and the Britishers way back in 1801 or somewhere. In 1853, the Britishers then actually kept aside the treaty now, because after the Raghuji III, the entire treaty was kept in abeyance. So now in 1861, so this Madhya Bharat, central province is created. Prior to that, where is Kamptee? Kamptee, which cantonment came up in 1821, you will be surprised, Mr. Whal pleads, that till 1888, Kamptee was under the Madras presidency, and the Madras Command or the commander-in-chief used to handle it. Later it was shifted to Bombay presidency. Now there is correspondence, there is notifications which Mr. Whal, before coming to the court, had been building up his case since 1990. He had been continuously doing correspondence, representations regarding Kamptee history, regarding the bungalows, regarding the documents, and after the RTI Act 2005, because this case was in pendency till then, he even started filing RTI applications, which I will be discussing later. So now he asked for, in his plaint, that nowhere the document of old grant is forthcoming, neither the department is producing. And the most effective part in this entire case, what Mr. Whal was doing, was that he was annexing every paper what he pleaded. So there was a complete set of about 600-700 papers which went along with the plaint. And you know, if I ask people today, I remember this bungalow owner from Jhansi, when his resumption case had come up, my president then wanted to support him on a free advice, and he made his plaint on resumption. And I yet remember that plaint ran into some 30-40 pages. So this bungalow owner categorically told me, when he wanted that I should vet the plaint, I said, since Deepak ji is doing it, I am not going to do it for you, and I don't do anything for free. So then he said that I have already paid 11,000 rupees to the association, so that is how you need to do it. So I vetted his plaint, and I told him there are many things which have to be added. And you will be surprised, I was surprised when he went back to Jhansi, his local advocate told him that this bigger plaint of 40 pages will not be acceptable, and the court will not grant us status quo. So let us draft the plaint in a very small manner, and he reduced that entire plaint into 7-8 pages. And today, after so many years, this is I think way back in 2015-16, and today he is the most legal luminary in the cantonment sitting. He goes around every cantonment. He has visited Kamptee also. He is the legal advisor for every bungalow owner, for mutation, for unauthorized construction. I know for what all he is doing what. He is just looking for money. These cases have to be fought like this. So now what happens is, after this plaint, the CO Kamptee, who is also a respondent and a defendant, he gives a written submission, and he only comes to the court and says, since this suit is to be debarred because the valuation of the suit is above 10 lakhs. So in 1998, the bungalow number 29 as per the CO is worth 10 lakh rupees. So the valuation of the court fees has not been deposited in the suit for declaration. Second, he says under 80 CPC, the notice was not given to the government. So this is the pleading. He doesn't counter anything else of the plaint. Now what does the DO Mumbai write in his written submission? Again he says, there are no documents produced by bungalow number 29 to say that he is a private property. Neither plaintiff is the custodian of these documents. So who's the custodian then? Bombay Presidency and Army Regulation 1875 when combined were under the Bengal Presidency. So Bengal and Bombay Presidency combined and created 1875 and 1887 Army Regulations. He talks of various codes, how registers are maintained, he admits. He talks of CLA rules, how GLR has been prepared and classifications have been given. Now he lists the limits of the Kamptee Cantonment. Now he limits them to 1888 for the first time. Now this is very important. Listen, 1821 the cantonment is being made in Kamptee, but till 1888 there is no boundary pillars of the cantonment notified. Then they are notified in 1890. Why? So there are two sets of notification. Now he talks of a settlement, the DO Mumbai, that when the Rupkar settlements were being taken, the 5 villages which made a part in 1862 are Vakloi, Yargadha, Ajni and Deva Ada were made out. So these are the names. I don't know whether I am pronouncing them right. So now the cantonment property register of 1872, he says. It was of 1873. He says that is not there. GLR 1925 is not there. GLR 1937 is there. So this all goes around. He mentions that the GLR is an authentic document as per Surinder Kumar Vakil 2002. Now friends, this shows that the written submission was filed by the defendant, that is DO Mumbai, not in 1998, but after 2002. How many years? 4.5 or 5 years later. So we'll talk of this why after 5 years. He denies the Treaty of Kamptee and he says these are historical facts, does not need to. So he does not buy the idea that in 1851 the order of private individuals were allowed to make bungalows as per the GGOs in Kamptee. So specific pleading that Mr. T.N.Whal came to court by writing on the wall, the DO is writing a slogan saying it is something like telling a cook and a bull story. How stupid it is. How obnoxious it is on the part of the defense state officer. Well, he is talking that some issues are irrelevant what Mr. Whal has documented or pleaded. So the plaintiff's application now comes in after this written submission that he wants to place on record, because this is now 2003 when this written submission is coming. Many such documents came in the hands. So even after those applications for asking for a short adjournment, the MU or the DO Mumbai does not reach the court for next 4 years. So Mr. Whal takes the pleadings under CPC. First he says striking out defense. He says since it was not done within the limited period, it should be done. Now what does the defendant say? That since they had moved an application for dismissal of plaint under order 80 CPC, so that is why they did not give a written submission. Done. Mr. Whal moves an application under order 11 rule 21 to find out the documents. He even moves an application under order 8 rule 11, 15, 16 for discovery of documents. Like because the pleading came up that Mr. Whal is not the custodian. So Mr. Whal gave a full list of documents starting from 1858 to 1887 as Annexure A. Annexure B, what was given by the written submission, were the notifications of Kamptee. Annexure C is talking of the Registration of Transfers Act as per the 1864 Cantonment Act or the 1880 Cantonment Act. The extract of private registers of bungalows from the period of 1821 to 1836 to last 1888. He is asking for all these documents. He is asking for register of transfer under the Cantonment Code. Where is that register of 1899 and 1912? Where is the private property register under the same code? Now he is asking for various acts passed during 1859 and 1861 in specific. This is prior to the Cantonment Act. Some bungalow registers whose sale deeds were already in possession of Mr. Whal, he is asking for those documents also. But you are the custodian, now you bring them. Various notifications of the presidencies of cantonments, let's say Ambala, let's say Barakpur, let's say Sikandrabad, under what notification in which they fell in presidency. So finally Mr. T.N.Whal, after filing this application and getting no record from the department, he moves his chief, that is he comes as an evidence. So PW1, his chief affidavit speaks into some voluminous 10 pages and he marks all the exhibits which he wants to tender, which he's already put them on the plaint along when he was filed. Now in para 12 and 14 he pleads all letters of 1858 and various sale deeds of bungalow numbers and also RTI application. Now this is after 2005 RTI Act. The chief is being happening. Once all this is documented, exhibit from 107 to 231, another added 135 documents are exhibited by Mr. Whal in his chief, apart from what he had in his plate. So Mr. Whal in 2007 again moves in application under order 18 rule 4. He says, since I have already given my chief, I have already tendered some document. Now some additional documents have come in my hand, which I want them to be a part of my chief only. So he moves this application, and the court allows him on oath that yes, you can tender these documents because they are very vital for your pleadings and court. So friends, we just have to understand how Mr. Whal was taking his case. He was building it one by one, step by step. I will even request the Jhansi legal luminary, if he is moving around in the cantonments, I am very worried about his doings. Because sometimes when people don't talk, you feel scared. This is a massive knowledge. And you cannot miss out one point, like Mannalal Agarwal missed one point, the notification of 1950. And it was 40 years of his fight was brought back to the lower court by an application under order 41 rule 27. So these letters, now which he had been working since his mother's death and writing to the department, that is the MEO, Director General Lands, Ministry of Defence, Defence Secretary, giving representations to Raksha Mantri, he brought all of them on records. And everything was tendered in the court. This is very important. The court has taken a very serious note of these applications and these representations of Mr. Whal. So please, bungalow owners, start writing letters to the department if they are not doing anything for you. Another letter in 1993 states that in 1920 land was also sold by owners. In 1997, he issues two important documents, the GLR of 1933 and a house property register of 1877. Now, where are these documents coming in the hand of Mr. Whal is a question. So, meaning hereby that if record is called for in the court for the Kamptee Cantonment people, imagine what all can you achieve. Now, he demands documents of bungalow number 72 because in his letter and in his plaint, he's tendered such documents. He's another states about bungalow number 114, 61, 88, 48, 29 was his. He claims that these are all freehold bungalow. So friends, we can all do this. This is a masterpiece case, like Mannalal Agarwal. Now Mr. Whal has even pleaded a Governor General Order number 227 of 6th June 1862. He even refers to the MLM page of 221. Now what is this order speaks? House built on land not the property of government or held on freehold tenures or occupied as shops are exempted from these liabilities or this liability. Rules not to have retrospective effect. Now 1862 he says no rule is to have retrospect. And houses built prior to the establishment of military jurisdiction not been included under these rules. These rules are not to have irrespective effect, nor are they to disturb the residence of officers and others at the present moment, except in case of extreme and proved public inconvenience. Their object is to secure gradually and as opportunity offers a better arrangement for the future. So in 1862, the department in the Governor General orders admitting that there are private properties in the cantonment. Exhibit 18 of the same speaks what I have been consistently saying, that CLA rules are not applicable on us because we fall under Rule 3, Sub 4. Lands in Category 3 is private land over which neither the government nor the Cantonment Authority possesses any rights except for the control of assessment, of taxation, or the enforcement of sanitary control. I'll ask a simple question to everybody. How many superintendents does your cantonment executive officer have? Let's see how many people know. There are 3. One is the building inspector, the other is the taxation superintendent or inspector, and the third is the sanitation inspector. So these are the only 3 rules which can be made applicable on us. Mr. Whal, who had been working for this evidence, has created all this evidence against the ministry through his regular correspondence. Some bungalow owners, I remember when I was guiding some bungalow owners, they said, Mr. Das, by writing these letters which you are asking us, don't you feel we will antagonize the system and the department or the officer? Are we concerned about our relations, or are we concerned about making my or your OGB a freehold? You have to decide this. Either you keep pleasing the department if you've done something wrong. Like I know Kanpur bungalow owner who's encroached the Ganga and is running a hotel. He will always please the department. He's only bothered to be there till he's there. How can he stand up and fight for you? He cannot. So there are many bungalow owners like this who only look for their gains. Now there is another exhibit 219. This is again a letter of 1992, which is again showing sale deeds of bungalow number 29, 20, 32, 24, 62 and 40. I request all these bungalow owners which I mentioned earlier and now, either please go to the court or get in touch with Mr. Whal, get these documents out and build your case. If not, you can always come back to me. We need to first create our evidence. This is what I am asking everybody. I am asking every bungalow owner, please, why I say a Janam Patri, because the second part of the Janam Patri is that start writing executive letters, start corresponding with the department. Ask them under various rules, various doings of your property. This is how you will be coming to the court by saying, look, I was writing a letter and they were not replying to me. So exhibit 16, 17 is again showing land records made by the Patwari of 1861, which earlier has been pleaded, where he is clearly rating that the proprietary rights are with those occupants and they are called Malguzar settlements. So remember, there is a judgment of Jabalpur I mentioned, 1934. It is the same Mr. Menzel who had done this settlement during the period 1861 when he was the first appointed governor. So exhibit 222 shows Kamptee has 115 bungalows. So please, Kamptee bungalow owners, check, are you 115 anymore or you have decreased? And there are approximately 16,616 bungalows in civil area. Now these are those bungalows which could be smaller property, 200 acres, 200 square yards or that way. So where are these? Where are these OGBs? Now all these documents, these sale deeds are coming forward, GLR is coming forward, not only of the 1937 but of the 1925 also. There are property registers of 1877 of these bungalows. So why is the bungalow owners whose sale deeds and documents are not there are please understanding the whole myth of this case? Mr. Whal built up his case. Are you building up your case? No, you people are not. I know you people are all quiet. You are lying low. You are not wanting to trouble yourself into all this. You are saying when something will come, then we will propel. Exhibit 7, he puts a register of 5th September 1888. GLR of 1925, survey number 101 to 122, then 190 to 196, all are written private. Now, who are these survey numbers? Can all get into touch? We can all make a small association of these many people up there. Let's educate ourselves and move forward. There is a Maharashtra Gazetteer being shown. What is it showing? That prior to 1821, the total land which was taken for making of cantonment was about 5,103.72 acres. But later it was reduced in 1927 to 1,042 acres. So where is the balance approximate 4,000 acres gone? So the pleading of 1880 that it was a part of Madras Presidency is the correspondence with Mr. Whal is showing. So Mr. Whal has excellently built up his case from 1990. He kept digging documents, kept researching. 2005 RTI, and then he even filed a suit. So now the department exhibit 167, which is very important. It is a notification of the Quartermaster General Shimla of 12th May 1877. Now this shows under the Bengal Presidency and various other provinces which all cantonment is falling. Bengal Presidency which all fall, Northwest Province which all bungalows fell or cantonments, Central Province, Awadh Province, Punjab Province, then Bombay Presidency, then finally Madras Presidency. So these all cases, these all notifications are there. Now when the argument is taking place and the counsel for the government is only up to a story. So nowhere the counsel is objecting to these documents to be exhibited. Nowhere there is a countering coming. So Mr. Whal very smartly puts up a case which was an exemplary case of bungalow number 36, exhibit 171. That was Secretary of State India versus Ramshahi, owner of this bungalow. I would request bungalow owner, is 36 bungalow owner test case is yet available with people up there? So government offered this bungalow owner in 36 that you convert your old grant bungalow into a perpetual lease. Why? Ask yourself. I am happy. I know why they asked it. Please ask this bungalow owner to get in touch with me if he exists anymore. Now with these documents and these exhibits, in today's case, finally the court had to pronounce the order, and after 11 years on 8th May, the court in 2009 pronounces the order. Now what are the order and what were the issues made? Does the plaintiff prove that he has become the owner of bungalow number 29 on serial number 175, Kamptee Cantonment, after the death of his mother, Vidyawati? The court answers yes, in affirmative. Does plaintiff prove that non-mutation of plaintiff name to serial number 175 is illegal? Yes, it says. Does the defendant prove that the land under bungalow is held by occupancy rights subject to land grant tenure as contained in GGO number 179 of 1836? It is in negative. Department could not prove. Whether the suit is bad for want of notice of ATCPC, the court says negative. Whether the suit is bad, barred by limitation, the court says negative. Now where this limitation came is, I'll just tell you in the order now. What order and degree? That's a simple order. So the whole suit is decided on these main 6 issues. whether the plaintiff is entitled for relief of declaration and injunction as sought. The court says yes, he is entitled. So Mr. Whal's case is entirely a flown case. The department, is unbelievable on the kind of evidence. So that is why I say, please, department does not have anything. We can hammer them the way we want them. My lord stated, Mr. Whal kept trying with the department to get his bungalow mutated after the death of his mother Vidyawati, and wrote enormous letters to the department, and finally it said you may go to court. So just imagine, his entire correspondence has come to the court. It is because, according to him, there has been volume in exchange of letters, correspondence between him and the government authority, wide exhibit 44 to 101 and 107 to 213. Just see the number of letters and representations requesting defendants and authorities to mutate the bungalow in his name as absolute owner of the suit property after the death of his mother. But the department did not do it. As pointed out in para 17, having given sufficient opportunity, defendant number 1 and 2 preferred not to appear in the matter for their evidence. Look at the plight. However, Mr. Aglaway, the AGP appearing on behalf of the MEO, Union of India, did cross-examine PW1 T.N.Whal. However, neither significant has been cited from her cross-examination in favor of the defendant. So she could not, these were notifications in letter, how could she say whether they were wrong and to be produced? In regard, Mrs. Aglaway's intention was only to bring the court to a judgment or an order of a civil appeal number 800 of 1972, Tarvinder Singh versus Government of India of Bombay High Court, Nagpur bench. And she said this final case has gone to the Supreme Court and the order. But where is the case? Where is the order? Where is the pleading? Nothing she could bring on record. So the learned advocate for defendant number 2, that is Cantonment Board Kamptee, preferred not to cross-examine Mr. Whal, even after getting n number of opportunities. This case for 11 years was only on pendency of the CO and MEO. Thus, considering the entire material on record, coupled with the sale deeds exhibit 112 and will date exhibit 113, and the series of correspondence between the parties pointed above, I have no slightest difficulty in coming to the conclusion that the plaintiff has become the absolute owner of the suit property, bungalow, after the death of his mother. Besides this, he is proved by way of legal admissions, manner that having done series of correspondence with the defendants, government authorities, his name has not been mutated in the record of rights as of absolute owner of the suit property bungalow, has no valid reason. This is beautiful. So other issues were also vetted and decided in the whole case, and was in favor of Mr. Whal, as he produced not only evidence, what I have been saying, like Manal Agarwal, but he even managed to hold back that evidence, move applications, produce secondary evidence, because the department had pleaded, where is this record coming to? Is Mr. Whal the custodian of the record? So you have to understand, by themselves they don't want to bring records. When you ask for record, they don't bring records. When you want to move secondary evidence, they move objections to it. They don't want you to, because you generally have photocopy documents. So what do? Please, bungalow owners, try and understand. I just mentioned a case 3-4 days back of Agra. where Mr. Yuluddin had lost his case only because he could not produce and prove his documents of 1800. So we will also, Ghaswala 1864 sale deed. Mannanal produced his grant of the Raja, and he actually proved it also that this grant was made. So here Mr. Whal has done the same thing. We can all do this. We can all do this. My humble request, please, these bungalow owners whom I mentioned, please call me, talk to me, build up your case, get in touch with Mr. Whal's son. I'll be grateful. Once again I am saying, we are old grants, never converted into new grants. Thank you. Good day.